Hello, we're just going to wait a little bit longer to let more of the attendees in, so please just bear with us for a few more moments.
We hold back the tide of people.
Just another minute and then we'll start. Okay, hello everybody, my name's Rachel Segal. I am one of the barristers in the personal injury and clinical negligence teams at St John's Chambers. Welcome to this latest webinar in our series of autumn webinars. As you know from the billing, this is centred around Highways Act claims, and in particular what we thought we would do today is to try and open up a little bit of discussion about the kinds of common evidential issues that arise for both claimants and defendants in what we'd probably describe as straightforward or relatively basic Highways Act claims. So for the purposes of today, it's a little bit artificial in that obviously it won't be a full mock trial, but what we're going to do is to show you the closing submissions of the counsel for the defendant, who on this occasion is going to be played by Jonathan Lindfield. And then we'll hear from the counsel for the claimant, who today is David Forster. And then I will, pretending to be District Judge Segal, I will be giving judgment. And in between the submissions and then the submission of data from the claimant and the judgment, what we're going to be doing is asking you to interact with us by use of some polls, so some questions which will appear on your screen if you're joining us live today. The questions will appear on your screen and you'll be asked to vote on the specific questions, and then we'll look at the results at the end. I should give you a little bit of background information as to the nature of the claim itself, and also to say that we should assume that during the trial, which we're pretending has already happened, that we've heard oral evidence from the claimant herself, and also on behalf of the defendant, the witness in the form of the highways inspector, who works for the defendant now. And just to give you a little bit of the detail, the claimant herself is a 42-year-old administrator. The accident happened at about 1 o'clock in the afternoon on the 25th of November 2018 in Redcliffe Street in the centre of Bristol. On that day, the weather was clear and sunny, and the claimant sadly tripped on a raised paving slab and then fell heavily onto her left wrist, and she sustained a minor undisplaced fracture of the left wrist. She ended up in a plaster cast for 6 weeks. She had to have 3 weeks off work. She was on light duties for another 10 weeks. She had a course of physio once the plaster was removed. The GP prognosis was for a full recovery at 12 months from the index accident. Quantum has already been agreed. In fact, it's been agreed in the sum of 7,500, 4,000 of which is general damages, and of the specials that includes contractual loss of earnings, gratuitous care, and some physiotherapy. So that's the sort of background. That's to give you a flavour of where we're at. So I'm going to hand over now to counsel for the defendant, Mr. Jonathan Lindfield.
Thank you very much, Mum, and thank you very much for that summary of the evidence. And I will proceed then on the basis of Mum setting out at the outset that importantly, in this case, the defendant accepts that it is the relevant highway authority, and it also accepts that this is a Section 41 type case. You'll be glad to hear, Mum, that there is no dispute about whether this is a highway maintainable at public expense, which of course we could spend hours on another day. But so, Mum, what does the claimant have to prove to you? The claimant has to prove to you that the highway was dangerous. It was dangerous due to want of repair, and that want of repair caused this accident. Now, James and Preselli, the case tells us that that ought to be a defect that the highway should reasonably put right. And I would also draw your attention to the case of DeBell, where we know that we're looking for a real source of danger. All of those tests are largely similar, Mum, but what I'd say from the outset is that it is clear that any measure of dangerousness is one for you alone. The fact that the defendant sets its intervention levels, etc., which I will submit to you further later, it is not simply the fact of this accident happening or that there being an intervention level that the defect exceeds being a measure of whether this claim should succeed or not. Now, how does the claimant go about proving that to you? First of all, she needs to prove to you where she fell. And the reason I say that is because the case of James and Preselli also tells us that the claimant needs to point out exactly where she fell. She can't rely on the general state of the road as it appears. It is certainly the case that what we know from the evidence you heard earlier, that the claimant did not take the photographs you have been referred to. Now, Mum, perhaps this would be an appropriate occasion for me to share with you those photos that you've already seen. Mum, can I check you can see those?
Yes, thank you.
Now, importantly, what we can see is this is probably the best photo the claimant brings to you of this defect. You will note a few things about it. Number one, there are no measurements on it whatsoever. Number two, it's heavily zoomed in. It's not at the level of the pavement. Now, all of those things I say are important because what we know is that the claimant's friend went back a couple of days after this accident and took these photographs. The claimant wasn't there. All the claimant can do is endorse these photographs saying, yes, that does look like where I fell. The difference being, you have heard absolutely no evidence from the person that took these photographs. You've only heard from the claimant. The claimant didn't take these. You haven't heard how the person that took these photos decided where to take these photographs. You haven't heard the method in which these photographs were taken. You don't know, for example, whether this is the state of the paving slab in its rocked state, in its unrocked state. And as you know, one of the things about this particular paving slab is that it rocks. Now, not only that, but given the fact that these pictures are rather zoomed in, the claimant, I say, and I would submit to you, Mum, cannot be sure that this is where she fell. Now, what the claimant essentially asks you to do is to eyeball these photos and say, because it looks like this is something you might be able to trip over, that is the most likely thing that she did trip over. Now, I say that, Mum, that is flawed for a number of reasons. Like I say, firstly, the claimant doesn't know. She tripped on something that she described as a big block of stone. But, Mum, there is no reason why it should be this particular thing more than any other thing. The claimant doesn't give you any further information to know whereabouts she fell, what she remembers being around her, all those sorts of things. Just she knows she fell. She sends her friend back in the next couple of days to take these photos, and this is all you have. Now, Mum, yes, Mum.
Mr. Lindfield, wasn't the claimant very clear about, in her evidence, that in fact she tripped with her left foot and she fell forward, and that the point at which she landed was further forward of exactly this photograph that you're showing me now?
Well, Mum, I mean, that's a point for you to assess the claimant's evidence, but the fact that she tripped with her left foot is neither here nor there. She could trip. There's a number of things one can trip over. The point is whether it's dangerous and whether it is this that she tripped over. She did give evidence that she fell forwards, but that is unsurprising given that when you trip, one often falls forwards. I say that the claimant, first of all, can't prove to you that this is where she fell. But Mum, let's say you're against me on that, and you say this is probably where she fell. The claimant then has to bring to you further information about actually how deep is this, because clearly, Mum, from this photograph, you've got absolutely no information about how deep this is, how far above the pavement it stands. And to that extent, the claimant has brought you other photographs. This is the first of those other photographs. Mum, clearly this is a wholly inappropriate way of measuring the depth of this defect. Mum, you will have seen recent High Court authority, Nash and Hertfordshire County Council, Walsh and Kirklees. All of these cases point out that it is important that claimants do their job properly when it comes to measuring defects, when it comes to showing the court and proving to the court that there is enough reliable evidence so that you can say that it was more likely than not a real source of danger. And this photo does not do that by any stretch. The next photo you have, Mum, is a picture of a man's boots. This is, of course, the person that took these photographs the day after. Again, no reliable measure. Again, the claimant is asking you to infer from these photographs that the defect is dangerous. Mum, again, the point is, this is a rocking paving slab. One of the important things you would need to know is, how does the claimant get this paving slab to look like that? Is this at its minimum? Is it at its maximum? Does one have to stand on it to get it to look like that? That is all important information that you don't have because you don't have any evidence from the man that took these photographs. Perhaps the best photograph the claimant can bring to you is this one, Mum. And this, unfortunately, is still not enough. Now, what you've got, and hopefully, Mum, this photo is now zooming in for you as well.
Yes.
You've got a plastic ruler which shows that at some point along this defect, it is about 30 millimeters proud of the surface. However, Mum, in my submission, this is flawed for a couple of reasons. Number one, you can clearly see the bottom of that ruler is not at pavement level. It's pushed into the gap. Now, Mum, who knows what difference that makes? When we're talking about very fine margins, and we know that the council's intervention level on this is 25 millimeters, it is, when we're talking about fine margins, the claimant needs to be exact. The other point with these photos, Mum, as I say that in my submission, this is one of those rulers where there is often a space between the first marking on the ruler and the actual plastic frame of the ruler as well. And when you take that into account, in addition to the fact that this ruler has been pushed into the soil, then, Mum, I say there's no reliable measure at all of how deep this defect is. Again, as I said at the outset, what the claimant asks you to do is eyeball these photos and say, A, that must be where she fell because she fell, and the defendant says that's not good enough. The second thing she asks you to find is that it was dangerous for the measurement that has been provided. Now, when the claimant is there with a ruler at the point, at the thing that is she says is dangerous, question even why the only photo you have is one that is measured here. It was measured here for a reason. Perhaps that's because that's where the person that took these photos says the claimant fell. Who knows? You've not heard any evidence from. So, Mum, the photographs in this case are misleading in the defendant's submission. There's no reliable measure of any depth, particularly when the claimant relies on the fact that the thing she tripped on was on her left foot. And clearly, Mum, that's because the left-hand side is more proud of the soil of the rest of the pavement than the other. Now, in that regard, at its lowest on the right-hand side, we are clearly below intervention level. On the left, we're clearly, we're not clearly either way, we don't know. But the point is that I would ask you, Mum, to form a very narrow reading of James and Priscilla. Not just that the claimant needs to show that she fell on this bit of pavement, but she needs to show where along that bit of pavement she fell, because it's important, because you need to show that it was the want of care that caused this accident. And clearly something that is well below the intervention of the right-hand side is not due to want of care, because the danger appears, it seems, if anything, on the left-hand side. Mum, not only that, but what you have is an area of pavement that is relatively highly trafficked. We know that the claimant herself, as well as many others, will have walked back and forth across this pavement a number of times. And this blends over with the submissions I'm going to make to you on section 58. But in effect, no one's complained about this that we know of. And Mum, I'll come on to the other point about there being a public report in just a moment. But for the lots of people that walk across this, clearly not even the claimant has pointed this out as being dangerous. So Mum, on section 41, the defendant says that the evidence is incomplete in that you should have heard from the person that took these photographs. Insubstantial in that even when they do bring you evidence, it is not enough. It does not give you enough to reliably say that this defect is dangerous. And the evidence is unreliable because of the way in which it has been measured, the method in which these photographs have been taken. We know the photographs were taken a few days after the accident. And we also know this paving slab rocks. So in all those circumstances, I say the claim fails on section 41. However, if you're against me on that, of course, the council has its special defence under section 58. And the defendant can absolve itself of liability if it showed that it did all it reasonably could to ensure that the highway was safe for traffic. Now, Mum, one of the things that I'm sure you will be live to is that the highways inspector you heard from was not the highway inspector who performed the inspection. And to give you a timeline, Mum, just to refresh your memory, we know that this road is subject to 3 monthly inspections. Mum, I don't anticipate that any issue is going to be taken with that. And this accident happened 1 month before the next regular inspection. So, Mum, it is unfortunate that this claim, the accident happened towards the end of these regular inspection periods. But of course, that's not the defendant's fault if they have a reasonable system of inspection. But to return to what I said, the highways inspector you heard from did not carry out that regular inspection before. However, he did give evidence that he was working at the same time as the other inspector. He knows how things were done. He knows that this route was walked up one way and down the other. This is certainly not one of those cases, Mum, where you've got inspectors saying that they drive down the road and also check the pavements by looking out of the windows, for example. This is a very reasonable system, I would say, of checking for defects in pavements, especially on these highly trafficked areas.
Mr. Lindfield, can you just help me with something here? It was very clear from your witness today that he remains in contact with the highways inspector who carried out the pre-accident inspection. He's friendly with him, he's in constant contact with him. Can you explain to me why it is that we have absolutely no evidence from that gentleman at all?
Well, Mum, of course, it is unfortunate that this person was potentially contactable and hasn't given you any evidence. However, when we're looking at what best evidence is the best evidence you can hear from someone who no longer works for the council, has been out of doing this week in, week out, or from someone that was there at the time, knew how these things were done, and can give you that good evidence and still does that job. Now, Mum, I can't assist you with precisely why he's not here, but I say that is not fatal to the defendant's section 58 argument, in that you can still have reliable evidence on whether these things would have been picked up on previous inspection. So in that vein, then, you heard compelling evidence that these sorts of defects can spring up quickly. They do happen, especially on heavy footfall walkways, and that this is a rocking paving slab. And so, Mum, I would say that looking at that previous inspection, we know that no actionable defects were recorded. It is unlikely that an inspector walking along would miss a defect of the nature that the claimant describes. And in all the circumstances, it is unlikely that it was there at the previous inspection. Now, Mum, what we do have is the complication of the fact that there was a report from a member of the public for an area that we know is at least nearby this defect. The evidence you heard from the highways inspector was that actually he hadn't noticed that in the records before today, and doing his best, he told you it looks like it's about the same area, but he can't be sure. Now, Mum, I say there are two things that are important about that. Firstly, there is no mention in that public report that the slab was a rocking one. That tells us, I say, one of two things. Either this slab was not rocking at the time that it was reported and now does, in which case it has clearly deteriorated before the claimant's accident, or it's not the same one.
Or, Mr. Lindfield, surely it's possible that the member of public that reported it on the basis of what they saw and not what they felt on walking over it. Is that not a third possibility?
Well, Mum, it is unfortunately entirely impossible to know when the only thing we receive from a member of the public is what we receive. Now, importantly, you will have heard the evidence is that the inspector didn't go out to look at that public report because the member of the public hadn't reported the depth of that defect. Now, Mum, I say it is entirely reasonable in the circumstances that when we know, and I think it's not too far to say that in almost every highways issue, we're talking about the depth of these defects, especially on walkways when they are tripping hazards quite often. Now, if the council had to respond to every single report that doesn't have a depth, then, Mum, it couldn't be a reasonable system, I say, because that is way far and beyond a council of perfection. Now, what the council clearly does do is it does go out and reactively inspect, but when we have something where the depth isn't reported, Mum, I say it's entirely reasonable that it wasn't gone out to look at. Now, I say that's not the same as saying that we don't have the resources to do these things, Mum. I say that what that is saying is that it's simply not reasonable to go out to all reports that are made without a depth, when that is the thing that we are most concerned with. And, Mum, particularly when the form that they fill out asks for a depth. And if it was important, Mum, would anticipate that the public would mention it. So, Mum, there is good evidence in front of you that there is a reasonable system of inspection, which A, would have identified this defect had it existed at the time of the previous inspection, would have identified it at any other time had it been made had the council been made aware of it. And I say, actually, Mum, we cannot be sure that that public report was of the same defect. Again, in the same way as the claimant asks you to infer that about the pictures she has taken, they also asks you to infer that about the report that was made. So, Mum, in all those circumstances, the council can, of course, make out their Section 58 defence. There is a reasonable system. Unfortunately, Mum, I invite you to find as a finding of fact that this rocking paving slab has sprung up, as it were, between the last regular inspection and this claimant's accident. Lots of people walked over it with no report of any danger, and, Mum, I say that is conclusive in the case. And in that circumstance, I'd invite you to dismiss the claim. The only alternative I would put in front of you is, of course, the claimant gave evidence that she was walking along carrying her food. She was talking to her friend on the way back from lunch. So I say there is space for contributory negligence here if the claimant wasn't looking where she was going and taking reasonable care. And I say that starts at least at 50-50. Mum, unless I can assist you any further.
No, thank you, Mr. Lindfield. So we're going to pause there and we are going to ask some questions and ask if you would please respond to them. So I'm going to say, Hannah, can you put up poll 1, please? Thank you. So the first question, and that there are no right or wrong answers here. I can say that, but John might have a different view. The first question is, was the defect dangerous? So in your view, having seen what you've seen and having heard the submissions on behalf of the defendant, do you consider that the defect was dangerous? So if you could please answer yes, no, or maybe. Okay. So I don't know whether we can see whether everyone's responded yet, and I'm hoping that my colleague Hannah will let us know. And are we ready to go on to the next question in this first poll? If so, Hannah, if you could put that up as well, that would be great. Just waiting for everyone to respond, okay? We're not going to come chasing after you if you get the wrong answer, don't worry.
And of course, the right answer is that the defendant wins.
Yeah, I'll ask you to disregard that comment. Okay. Oh, look at that. Was the defect dangerous? Yes, it was. 48% of you. Wow. Has the defendant done enough to make out a Section 58 Highways Act 1980 defence? The majority, well, not the majority of you, but 45% said yes, 33 no, and 21% maybe. Actually, on the was the defect dangerous? There are 21% of you who are hedging your bets. Not sure. Maybe. Interesting. So as things stand, we've got 48% of you saying that yes, the defect was dangerous, 30% of you saying it wasn't, and 21% of you hedging your bets. As far as the Section 58 defence is concerned, it looks like, yeah, 45%, as I say yes, 33% no, and the hedgers 21% again. I wonder if it's the same people. Okay, so bearing that in mind, and bearing in mind we're going to be going through a similar process after we've heard David's submissions on behalf of the claimant, I'm going to say thank you, Mr. Lindfield, and I'm going to hand over now to counsel for the claimant, Mr. David Forster.
Thank you, Ma'am. I should start off by saying that Mr. Lindfield is right when he says that the claimant has to prove, for the purposes of Section 41, the Highways Act 1980, that the defect upon which she tripped was dangerous. It is also, Ma'am, I have to accept, correct to say that there are some problems with the photographs. And it is right to say that we cannot provide a precise measurement of the exact point at which the claimant's foot contacted with the raised paving slab. And whilst such a measurement would certainly be helpful, Ma'am, the test, as per the authorities of Mills and Barnsley already mentioned, the test is not whether the defect exceeds a certain or specific amount of millimeters above the pavement. The test is simply, was the defect upon which the claimant tripped dangerous? And as has already been alluded to, James and Preseli clarified that for a breach of Section 41, the defect needs to be the sort of danger that the authority could be reasonably expected to guard against. And Ma'am, in my submission, there is sufficient evidence before the court to find, on the balance of probabilities, that the defect that we are talking about here was dangerous for the purposes of Section 41. There are some findings of fact that can be, in my submission, comfortably made by the court, which can assist with this. It is right that the claimant was not present for the photographs, where the photographs were taken, and that Mr. Oldham, who took the photographs, has not provided a witness statement. Despite that, Ma'am, in my submission, the court can comfortably find that the paving slab in the photographs provided is the one that caused the accident. We know that Mr. Oldham was a witness to the accident, so would have seen what caused the claimant's trip at the time. As we can see from the photographs, the first photograph shows without any sort of reference point. Bear with me, Ma'am, while I share my screen.
Of course.
I'll go to this photograph.
I can see I can see an image. Oh, I just seen another one. So I can see an image with no ruler or anything else, just paving slabs.
Yes, that's the intended image. You can see, Ma'am, it's a fairly distinctive paving slab. It has a large crack running through it, and it is raised in that manner, raising up from the right-hand side as we look at it to the left-hand side as we see it on the screen. And the photographs were taken within a few days of the accident, and in her oral evidence, the claimant herself has confirmed that this is indeed the slab upon which she fell. So in my submission, ma'am, there is little difficulty in making that finding of fact, that this is the paving slab. The second finding of fact, ma'am, is that the claimant tripped when her left foot impacted the stone. There is very little reason to doubt this assertion on behalf of the claimant. She has made the appropriate concessions where she needed to, but on this point she was quite clear that it was her left foot. And she was also clear that the impact upon her left foot was a significant one. She described it feeling like she kicked a block of stone. Again, ma'am, there's very little reason to doubt that. The third finding of fact that in my submission is assisted is that the claimant fell forwards over the paving stone. Now, whilst I accept the claimant hasn't been particularly precise about the exact point at which she landed, whether it was to the left-hand side of the slab or to the right-hand slab, as we look at the slab in those photographs, the claimant was reasonably clear that she fell forwards over that. Again, Mark. So with those findings of fact in mind, I'll take you back to the photographs. Mom, can you see that photograph without anything obscuring it?
Yes.
So it's quite clear that this paving slab shows a defect or a change in the height of the pavement that increases quite dramatically from the right-hand side as we look at it to the left-hand side. The next photograph, ma'am, is the photograph with the ruler.
Yes.
Now, there are valid criticisms to be made of this photograph, but when we zoom in, we can see an approximate measurement of 30 millimeters. We know that the defendant's intervention level for the footway is 25 millimeters. And whilst I accept Mr. Lindfield's point that the intervention rate, the intervention level, is not conclusive evidence of what is dangerous and what is not, in my submission, ma'am, it is certainly highly relevant to what the defendant himself, or the defendant itself rather, considers to be a dangerous defect upon the footway. What we can tell from this photograph showing the approximate measurement of 30 millimeters is that it is somewhere in the middle of the paving slab. It is neither at the right-hand side or the left-hand side. And you will note, ma'am, we can see a little bit of detail in the photograph, which I think we ought to be able to cross-reference with another photograph included. You can see a green shoot very close here. And if I take you back in my submission, ma'am, when we zoom in to this photograph, we can see a green shoot there. Now, in my submission, ma'am, there is enough there for the court to safely infer that this is the approximate area where the measurement was taken, and that measurement showed approximately, and I accept that given the ruler that was used and the potential mud between the paving stones, it's an approximate measurement of around 25 to 30 millimeters. But what is very clear, ma'am, is that anything to the left of that green shoot is going to be a significantly higher level of difference between the footway than what we see measured on that with that ruler.
Yes.
So, ma'am, given that the claimant strikes her left foot as she is crossing over this paving slab, in my submission, it is more likely than not that the claimant has caught her foot somewhere left of the point at which that measurement was taken. Similarly, ma'am, if we consider the claimant's description of the significant impact, there is a photograph which includes, I can get there, a boot here, and it shows quite close in the far left-hand side of this paving slab. And in my submission, ma'am, that shows quite clearly a dangerous defect upon which, if your foot impacted it, it would feel like a significant impact. It may well feel, as the claimant described it, that you've kicked a big block of stone. So, Mum, and the final point I want to make on these photographs, it's been mentioned that this is a rocking paving slab, although you will note from the claimant's evidence that she was ignorant of the fact that it was rocking. She did not discern that from her fall. But looking at this photograph, which should show you the slab without any measuring devices,
Yes.
you can see there is no weight or force being pushed down upon the slab at any point. It is in effect at rest there. So any concern that the court might have of the left-hand side being artificially raised by some force being applied to the right-hand side can be assuaged by looking at this photograph. We see the slab in its entirety at rest, and there is no force acting upon it to raise that left-hand side up artificially higher than it would have been at the time.
So, Mr. Forster, are you asking me to find that it doesn't matter that the claimant didn't know this was a rocking slab, that actually the point here is about the protrusion?
Well, the only evidence that we have of that it's a rocking slab comes from the defendant's inspector, ma'am, and doubt was cast as to the accuracy of the measurements provided in the photographs because of the rocky nature of the slab. But in my submission, ma'am, given that the claimant was ignorant of the fact that it was rocking, and the photographs show the slab with no force being put upon it, the court can comfortably find on the balance of probabilities that this is the appearance of the slab at the time that the claimant tripped on it, and that no pressure is being applied to the slab to artificially rock it to a higher level than it was at the time of the accident.
Yes.
So taking all of that into account, ma'am, in my submission on the balance of probabilities, there is, despite the problems, sufficient evidence for you to find that the claimant caught her left foot on the left-hand side of this raised paving slab, and at the point at which she tripped, following that significant impact, the defect would certainly have been dangerous for the purposes of section 41 and for James and Priscelli. Now, ma'am, if you're with me on that, then we turn to the question of section 58, and there are 2 points that I need to make with regards to section 58. The first is the defendant's problem with its evidence. It's already been noted, ma'am, that we haven't heard evidence from the defendant's inspector himself, despite the fact we now know it would have been possible for the defendant to get hold of him. I ought to say as well that Mr. Lindfield is correct to say that it is not controversial that the 3 monthly inspections are an appropriate inspection period for a footway such as this, and that there was an inspection 2 months prior to the accident. But if we turn to the language of section 58, it does say, for the purposes of such a defence, it is not relevant to prove that the highway authority had arranged for a competent person to carry out or supervise the maintenance of the highway, unless it is also proved that the authority had given improper instructions with regard to the maintenance of the highway and that he had carried out those instructions. Now, ma'am, where there is no evidence from the inspector himself, who was responsible for inspecting this area, then inevitably the defendant is going to have a serious problem proving what the statute requires it to prove, namely that he was given proper instructions and that he has carried them out properly. Now, it's been put forward by the defendant that no member of the it's been put forward by the defendant that the defect would not have been present at the previous inspection 2 months ago because it would have been picked up if it were. But, ma'am, without any evidence from the inspector himself, that is simply the defendant using its own assumption that it has a competent system of inspection and maintenance to prove that it has a competent system of inspection and maintenance. There must be evidence to support the contention. The burden rests with the defendant on that point. And without such evidence, in my submission, ma'am, the defendant cannot make out the section 58 defence. There's a second point which is related to the public report that was made about this area. And crucially, ma'am, it's a public report that was not responded to. The defendant's witness stated that he thought it probably was, it did look like the similar It did look to be similar to the area, but of course he couldn't be sure because no action was taken. Mum, I would remind you of the recent case of Crawley and Barnsley, in which the defendant authority received a complaint from a member of the public on a Saturday, but failed to take any action until the following Monday. This was on this was not on a street with the same level of footfall as this city centre street, and it was found that the Section 58 defence could not be made out in those circumstances, not on the basis of causation, that if it had been responded to, the accident certainly would not have happened, but simply that there was a flaw in the system, and as such the defendant could not rely on the Section 58 defence. And Ma'am, in my submission, there is inevitably a flaw in the defendant's system in the present case. It is said that the public report was not acted upon, A, because no member of the public mentioned the rocking paving slab. Well, Ma'am, you sort of addressed that point already, in which it said, well, it's not for the public to undertake a detailed inspection and to think in the exact way that a highways inspector might do and try and manipulate the stone. They are simply reporting what they see. And similarly, it is not reasonable for the defendant to expect members of the public to provide them with the precise measurements of the defects that they are complaining about. They are requiring the public to effectively usurp them in their role as highways inspector. So that leaves the defendant in a position where it cannot say whether or not this defect had been reported. They think it might be the similar area. They cannot say, and the reason they cannot say is because they failed to take action of a public report for reasons, Ma'am, which I say are not reasonable and do not indicate a competent system of inspection and maintenance. Once a public report is made, especially in an area such as this, in the central business district with high footfall, it ought to have been responded to promptly, and a proper inspection ought to have been undertaken. In the absence of such, Ma'am, again, that is a serious flaw in the defendant's inspection regime, and as such, it cannot rely on the Section 58 defence. So in summary, Ma'am, the claimant does have sufficient evidence to establish the dangerousness of the defect upon which she fell, and the defendant cannot establish the Section 58 defence based on its competent system of inspection. So unless I can assist you further, Ma'am.
You can, in fact, Mr. Forster. Can you assist the court in understanding why it is that we have absolutely no witness evidence from Mr. William Oldham? So this gentleman who was with the claimant at the time of the accident, and was the gentleman who took the photographs within a few days of the accident. Why don't we have a witness statement from him?
I'm afraid I cannot assist you on that point, Ma'am. I think there is very little dispute that the claimant has suffered an accident in this location, and it might have been thought that Mr. Oldham, simply viewing the trip, wouldn't have taken the case any further, although I do accept it certainly would have solved some problems had he been able to give some evidence on the photographs at the very least. But I'm afraid I cannot provide an explanation as to why he's not here. Finally, Ma'am, the contributory negligence point, which I ought to address.
Yes.
If you are with me on the Section 41 and the Section 58 points, I would point out that the location of this defect, it's in the central business district. There is traffic close by. It's close to Temple Meads. There's a large volume of people walking around. There are more things for the claimant to be focused on and to have to be aware of in this area than in your typical residential street or quiet pathway or things like that. So it is not for the claimant to conduct a survey as she walks to spot every defect in front of her. In this particular area, there are lots of things that pedestrians have to pay attention to, including traffic and other pedestrians. And as such, if there were to be a finding of contributory negligence, which in my submission there ought not to be, but if there were, it ought to be limited to no more than 15%.
Thank you, Mr. Forster. So now we're going to move to the next poll, and we're going to ask you similar questions. So if you could please answer them as soon as you can. So the first one, on the basis of what you've just heard, was, and seen, I should say, was the defect dangerous in your opinion? And then when you've answered that, do you think that the claimant has shown that...
I think they should say section 58 rather than section 41.
Well, actually, it's do you think that the defendant has failed in its duty to maintain the highway? But yeah, I suppose it should say section 58, but it doesn't know. Let's leave it as it is, just so that we don't confuse everyone. So let's see when everyone's answered. Yeah, and there's the flaw in our system, but there we go. Wow. Okay, so was the defect dangerous? 75% of you said that the defect was dangerous. 20% of you said it was not dangerous, and for only 5% of you are hedging your bets on this occasion in respect of the dangerousness of the defect. So that's quite a marked response on the basis of what you've just seen and heard. I acknowledge that I've in fact put up the wrong question, really. That's my error, and I apologise for that. I did mean to ask originally, has the claimant shown that the defendant's failed in its Section 41 Highways Act duty? And in fact, I probably should have asked this, you whether or not the defendant had done enough. But anyway, if we take it on face value, accepting that there will be a margin of error here because of my error, it will be 63% of you have said yes, that the claimant has shown that the Section 41 duty was not fulfilled. 30% of you, so nearly a third, was saying that no, the claimant hasn't done that sufficiently, and 8% of you said maybe on that. So that's really interesting. In a second, we're going to ask you to respond to 2 more questions, and then once you've answered those questions, I am very briefly going to give a very outline judgment. So last poll now, Hannah, if you could please. Who would you find for? Would you find for the claimant, or would you find for the defendant? And as I say, don't worry, there are no wrong answers here. And then we're going to ask you to think about who you think will succeed. So there's a difference there between who you would find for and who you think the judge will find for. So who do you think is going to succeed in the end? That's the second question that we'd like to ask you to think about.
I'm sure that Dave and I have had no hesitation in voting for ourselves.
I'm not voting at all. I think that would be really unfair. And I should say also, actually, and looking at the time, when this seminar has finished, you will see appear on your screen an evaluation, and we'd really like to ask you to complete that. I know it seems like we can't blow our noses these days without being asked to fill in some kind of survey, but it's a really short one, and we do take feedback really seriously. We want to make sure that our webinars are helpful and useful to you. So if you wouldn't mind filling those in at the very end, we'd be really grateful. Thanks. So I can see the poll is still in progress. What's going to happen is I'm going to, when I get the results, I'm going to just make a note of them and then give my judgment. Not that I'm cheating in any way. I'd just be interested to see what the contrast is between what I'm going to say and what you've decided. I don't know whether you get to see the results, but I don't think so. So it shouldn't ruin things. Let's have a look. I'll just make a note. Okay. Thank you. So, very brief judgment. I am grateful to both Mr. Lindfield and Mr. Forster for their very helpful submissions and for the way in which they've conducted this case, particularly some of the more difficult cross-examination today. I have to say, this is no criticism of either counsel, but I just wish parties would bother to prepare their cases properly. The photographs in this case were mostly completely useless. You know, we had a comb at one point, we had a boot in a photograph with no sense of perspective, no way of knowing what the measurements were. I do have to say, however, that I was just about persuaded in this regard as to the likely depth of the protrusion of the paving slab by Mr. Forster's submissions, having seen what appeared to be, as he quite rightly conceded, might have been 25 to 30 mil showing on the ruler, the blue ruler that was in the photograph, the only photograph that had any measurement on it whatsoever. But just about persuaded on the basis of his submissions that in fact, if it was 25 to 30 at the point of the sort of the midpoint of the paving slab, bearing in mind the very clear photographs of what is an obvious protrusion as the paving slab lies straight without any pressure on it at all, that in fact what we see to the left of that slab is clearly a dangerous defect in the pavement and is clearly the sort of defect against which the defendant ought to be guarding, because it's clearly something that a pedestrian using the pavement in the ordinary way it is likely to encounter and to cause them, well, if they encounter it, to cause them injury. I have absolutely no difficulty in that respect, as I say, save for the fact that I would really ask Mr. Forster you to convey to those instructing you my comments in respect of the photographic evidence, please. There are problems, as has been conceded quite rightly by both counsel. There are problems in respect of the witness evidence, or rather lack thereof, in that we do not have any witness evidence from the highways inspector at the time, despite the fact that we heard today that the current inspector is in close contact with him and could quite easily have contacted him. I don't have any evidence before me as to whether or not any contact has been made. And equally, potentially even more so, Mr. Oldham, who was there at the time with the claimant, took the photographs, so I'm told, and I accept that he took them. I've got no reason to disbelieve that. But there's absolutely no witness statement from him. We've heard no oral evidence from him, and it's frankly not good enough. Having said that, and given that I consider that the defect is dangerous, we have to look at whether or not I can be satisfied that the claimant fell where she fell. In other words, that the defect caused her to trip and fall in the way that she describes. Her evidence on this was clear, it was compelling. She was pushed quite hard in cross-examination, but she was absolutely clear that she fell forwards, just beyond where the slab was. She did identify to me, to my task satisfaction, what she felt was the defect on which she had tripped and fallen. I have no difficulty in accepting her evidence in that regard. I am very troubled by the question of the public report that was made to the defendant. I should say, first of all, that I agree entirely with both counsel submissions that a 3-monthly inspection for this particular sort of patch on Redcliffe Street on the basis of the evidence that we've heard today and that I've read within the bundle, it's clear that 3 monthly inspections represent a reasonable regime of inspection for this sort of pavement area. And we know that at the point at which it was inspected sometime prior to the accident, that no defects were recorded. Of course, that's not the same thing as saying that there were no defects, and I do understand and consider that distinction. But what concerns me more than anything else is the fact that shortly prior to the claimant's accident, there had been a public report, a report by a member of the public for an area which was either the same as the defect or very close to the defect complained of. And we don't know, we will never know whether it was in fact the same. And what we heard from the current inspector was that he hadn't noticed the record previously to check. Well, frankly, that's not good enough. But when he did look at the description, he did say it does sound similar to the area, but of course, and I don't criticize him for this, of course, he just couldn't be sure. Mr. Lindfield makes the point that the paving slab was rocking and there was no mention of a rocking slab when it came to the public report that was made and that we can see in the records. But there are two things to say about that. Firstly, the claimant herself wasn't aware that this paving slab was a rocking slab at the time. But in any event, that protrusion is so obviously dangerous that I'd expect anybody looking at it would be, any member of the public looking at it would be concerned about it. But secondly, I think it's reasonable to assume that the member of the public who reported it thought it was dangerous and should not be criticised for not walking around with a spirit level and a tape measure in their pocket. They did the right thing in contacting the council. I consider that on the balance of probabilities, that in fact it is more likely than not that the public report for what could very well have been exactly this defect, that it's likely, more than likely than not, to have been for precisely the paving slab on which I found that the claimant has tripped. I particularly take into account the provision within section 58(2)(c) of the Highways Act 1980, namely that one of the matters I particularly have to take into account is the state of repair in which a reasonable person would have expected to find the highway. And given that I found that the public report was more likely than not to have related to this same defect, and given that a member of the public has clearly considered it to be dangerous to the extent that they've bothered to take the time to report it, I take that into account and consider that in fact the failure on the part of the defendant to investigate this public report, largely on the basis of the failure to provide a depth, I just think that's unreasonable. So from that perspective in particular, and also accepting Mr. Forster's submissions in respect of the failure of the defendant to give proper evidence about the instructions that were received by the inspector at the time with regard to the maintenance of the highway, and whether or not he carried out those instructions, which largely arises from the lack of witness statement from the inspector at the time, means that I do not consider that the section 58 defence in this case is made out. And it's for those reasons that I find for the claimant. I understand that quantum has been agreed. Thank you. So, so it's at this point that I let you know that the results of the last poll. So 73% of you would have found for the claimant. and the remaining 28% would have found for the defendant. And interestingly, there wasn't that much difference, but 75% of you thought that I would find for the claimant, so you were spot on there. And for the defendant, 25%. Although I have to say, it was, in respect of the decision, I know it's an artificial exercise to some extent, it was actually more finely balanced than you might imagine, for sure.
Definitely. If I was counsel for the claimant for real in the trial, there's no way I would be 75% confident, especially on the section 41 points. I would be, really thinking it definitely could go either way. It's just because I've had highways cases before where the evidence for the claimant is iffy like this, and judges will just chuck it out and they just say, well, you haven't prepared it properly, you can't prove your case on the basis of this. And it happens that the judge came down for the claimant on section 41 this time. I think we added in a couple of sort of lucky for the claimant details here, that the photographer was witness to the accident was probably the main one. But it would totally be within the court's gift to find that, well, you haven't made a proper investigation of the rocking, you're just assuming that it wasn't rocking, and without the claimant being present for the photographs, it's you've got a huge difficulty there as well. So it was very difficult, I think, for the claimant to get over the line on section 41 in that case. And I certainly wouldn't be 75% if I sat in court. No.
Yeah, I think what about you, John?
Yes, I think if I actually put my hand on the Bible and swear my oath, I would say that actually what I answered in the poll was I would find for the defendant, but I think you're going to find for the claimant. And I think the way in which this was designed actually highlights some important factors, in the sense of this was one of those cases that was the defendant's to lose on the basis of the claimant's evidence. She had got very poor photographs. The defect, although it looked dangerous just to eyeball it, I think it's important that that is often not enough. A judge needs to get over the line, and so you need to show them those things. But the defendant has kind of hoisted itself in the fact of, for example, the highway inspector who inspected it not being available. Now, it's perhaps the way we designed the point, and as you say, it's artificial. But in this respect, we said the highways inspector was contactable. In other situations, if he died or disappeared, or we don't know where they are, then we're in different circumstances. There's different things to take into account. But I think one of those things is that the reason the defendant doesn't make it home on the section 58 is for things that could have been remedied earlier on. Yeah. And I think that's the takeaway point, really, from the defendant's perspective, is in what we had was an inspector who, it seems, hasn't really properly been briefed on what is in the records. For example, he hadn't noticed that previous record that the public had made, and so we couldn't make a realistic evaluation of why things hadn't gone out, apart from the fact that there was no depth, etc. So those are the sorts of points that often appear for defendants. I'm sure those of you watching who have predominantly defendant practice will recognise some of these issues that come up. And I think a lot of it is about having, if you can't get the right people, I think actually to sum it up, it's get the best evidence you can and have a good reason. If you can't get the person who turned up, either get someone who was doing it at the same time, under the same instruction, walked the same route perhaps, or perhaps you need to seriously consider your position at an earlier stage. If the writing's on the wall, that is how that's what's going to happen. Yeah. I think, and also you make sure your inspectors read the records. How often is it that you go to a record and people don't know what's there or haven't appreciated it previously? Yes. So I think that is probably how we highlighted this case, is that the claimant's case had been presented in such a way that the defendant could have easily jumped on a section 58 defence, but has kind of ruined it for itself almost, if that makes sense. Yes,
definitely. I mean, from my point of view, listening to everything that each of you had to say, in the end, it really did hinge on that public report and the defendant's failure to do anything about it, and the really poor reason for it to do. I mean, you did a grand job in trying to speculate as to why that might have been, but yeah, I mean, that was the sort of the tipping factor in the end, as I say, for a case that would otherwise have been really much more finely balanced. And it's always difficult. Ultimately, as we've discussed in the past, the reality is that, you know, if a judge really wants to find for the claimant, they'll find a way. Equally, if they really want to find for the defendant, they'll find a way there as well. But exactly as you say, it's about the quality of the evidence and having a really careful think about what you have before you proceed to trial, for sure. David, was there anything that you wanted to add in respect of tips and hints?
On the section 41 side, which is what we were sort of focused, well, that was the sort of the main source of the claimant's problems in this case. It's so fundamental to get that first step right. Is photograph the defect, you know, to within an inch of its life. You know, make sure that it's there. You've got your tape measure or your ruler with your spirit level. You're getting photos of the setting. So that basically giving the judge as much information as possible. Like say, if this, it ought to be the first and most important step of any highways case is the defect. You know, I've had some cases in the past where it seems totally obvious that the person has tripped on a dangerous defect, but we can't prove it because the photos are similar to what you saw in this case, or they're too far out, or anything. And it's just such a shame for cases that have legs and that would easily go forward and be successful just trip over at the first hurdle. So it's really a question of evidence in highways cases. Yes. So yeah, that would be my main advice. And it's, you know, when you're at the stage where, you know, you're writing to counsel for an advice on liability or an advice on quantum or anything else like that, make sure you send all the photos. One of the questions ought to be, are these photos good enough? What more can we do? And, you know, be prepared to react to that. But yeah, that's the main takeaway from the claimant side is just, if you get your evidence sorted and your section 41 argument is therefore that much stronger, then, as John said, if the defendant does have problems with its section 58 defense, which they often do for reasons that have come up in this example of, we can't get hold of the bloke, or there was this one incident where we didn't respond to a report or something. If your section 41 evidence is good enough, then that may well be enough to make the defendant settle and not want to fight it because of the inherent risk with section 58. But yeah, that's the main way for me.
Thank you for that, and thanks to Julie Chapel. She says, thanks for putting on a really interesting exercise. Lots of good points to reflect on next time I'm sitting as a DDJ in one of these cases. Gosh. She said she particularly enjoyed the excellent scolding about the quality of the photographs. Yeah, I've been on the other end of that on more than one occasion, that's for sure.
So it's the old, I don't blame you, but now you're going to listen to it for 10 minutes.
Yeah, exactly. Are there any, do we see any other questions? Or let's have a look. So
there's one come through on chat there.
Yeah, can you read that, David?
So it's a question from Stephanie Sanderson. Is it normal to request a statement from the highways inspector? We do not normally ask for this, but wondering if it could be asked for.
Yeah, over to you, John, on this one.
Well, in terms of, you know, if you're thinking about best evidence, the person that actually went out and inspected it, if the court's going to be asking the question of what, you know, if the claimant is going to be raising the point, which is your system is bad because you missed this defect which was there and you've missed it, then the best way for you to say no, we didn't, was to ask the person who was there doing it. I mean, unless, you know, the inspector also takes photos of what he sees or whatever, that you're not going to have the best evidence on what was there at the time. And I suppose you can weigh it up with what the claimant brings to the court, etc. But certainly one would expect that a highways inspector who did the inspection, if they're available, would be the best person to give that evidence. I'm sure, I don't know whether Rachel and David would disagree with me on that, but I'm sure they will agree.
Yeah, absolutely agree. And I'd also say that a close reading of section 58 will absolutely support everything that John has just said. And so I'd suggest that, yes, it is something that would be a useful thing to do on a routine basis in these sorts of cases.
Question for the judge has come in, Rachel.
Yeah.
What would you have decided on the contributory negligence?
Oh yeah, thanks Layla for that. Actually, I would have decided there wasn't any contributory negligence on the basis that this was a woman who was walking back to, just minding her own business, walking across the pavement, walking back to work with her lunch. And you didn't know this maybe, but she was carrying her lunch at the time. It wasn't as though she wasn't looking where she was going, but she shouldn't have been expecting to be looking at the floor as she was going, and certainly not looking out for defects of the type that we saw there. I don't know if you'd have decided differently on contrib there, but thank you for that reminder, because yes, I didn't address it. The mechanics of the fall should have been investigated maybe as to where the claimant was walking in relation to the defect. Was she on the inside? Yeah, what you didn't know and that was in our note, because we were trying to create a scenario that would be relatively evenly balanced. And one of the things that we decided is that the claimant would have given actually quite clear evidence in that regard, that it was her left foot that impacted against the highest point of the slab, and she was on the left hand side, and that she fell forward. So we did know where she was relative to the defect. So she was to the left, if you like, of the slab.
But generally, you're right in that the mechanics of the fall can be important. I mean, I think sometimes it's easy to labour it as a defendant and say, well, she said she tripped with her left foot, or did she roll her ankle or whatever. And sometimes you can get into the nitty gritty. But when we are looking at kind of like sloping pavements or something, it is important whether you trip, whether you roll your ankle, because that can give you an idea of where they fell. So it is important. But certainly, yes, in this case, we should have. Yes, that was what we anticipated the evidence was going to be.
There's a great question from Gary Whitaker here, asking us whether we're a fan of Google Earth images, because as he says, they can establish a defect's been in existence for many years. I don't know if you know about this, but there is a history, sort of historical function or history function, whatever, that you can use on computer. When you're looking at Google Maps on a computer rather than, say, a handheld device or whatever, that I've used in the past, not that I can remember how to do this now, but where you can actually pinpoint when the image was taken, and it has a series of alternatives. For some parts of the country, I've actually been able to find 3 and 4 historical sets of images taken at different times, and it's actually really been massively helpful. If you're able to be absolutely crystal clear about when the image was taken and how you can demonstrate that, then I'd suggest that Google Earth images can be really useful. But if you can't, they have maybe more limited benefits. I think the key thing to say about any kind of Google images, whether it's Google Earth or Google Maps or whatever, I know your question's Google Earth, is the quality of them when they appear in the bundle, whether it's an electronic bundle or a paper bundle. The number of times that there might have been a satellite image of an area or an image of a map or whatever, you just can't read it because it's so poorly being copied so many times that the quality of it's so poor. The judge can't actually make anything out. So you can be making all sorts of submissions on that, on the basis of an image, but if it's not clear, it's completely useless. I don't know if the others agree with that.
Yeah, of course.
I think I'd echo that. Especially, I mean, it's often quite useful for big defects, isn't it? Because if you sort of scroll back a year or so and there's a whacking great defect still there, that's really helpful.
I found it useful for drain covers and sewage, the manhole covers and stuff like that are often very good to spot on Google Maps.
Yeah. Oh, definitely. That's a good point.
Less helpful if it's kind of on the pavement or it's not quite clear. It can add to the overall picture, but I wouldn't expect it in that case to be determinative.
Yeah. David, can you take the next one? If a defendant was to deny straight off, that one from Stephanie.
It's quite simple. Good records. So in this case, for example, you'd want the inspection records for the 3 months previous, records of remedial works that are being undertaken in the area. sorry, advising what disclosure you would, to try and argue against this? I beg your pardon,
Yeah.
I didn't read the question quite properly. Yeah, you want the records basically of all the inspections. You want to see the times of the inspections, predominantly that the inspections fall within the highway authority's own sort of parameters of when they said they have to be done, because sometimes that can happen as well. They go outside of their own time zone. Yeah, evidence from inspectors themselves, or whatever notes they've taken. But yeah, that would be the first thing I'd be looking for as a claimant from the defendant, is show me your inspection and maintenance records here, and they better be good.
Yeah. And then we just need one more question, which I'll read it out and ask John to deal with this one. Stuart Ford, if the authority had inspected, the inquiry would have the defect have been repaired prior to the claimant's accident, as the defect was close to the intervention level? John, can you deal with that?
Yes, how I read that question is sort of the causation point. I think is what you're saying is, if the authority had inspected, would it have been fixed by the time the accident happened? And the answer is actually, if you haven't got a good system, the causation point won't save you. So, for example, you can't say, I know we didn't look at it, but even if we had, it wouldn't have been fixed at the time. That simply won't get you home. There is authority on it, which is not jumping to the forefront of my mind, unfortunately, but there's certainly a bit, take it from me, that is a point of authority, that the causation point won't save you in those circumstances. It's different if you have a good system, and that is fine. If you have a poor system, you can't save it by saying, well, even if we had gone out, we wouldn't have fixed it in time.
And finally, we can squeeze this last one in from Sue Leeming. If the claimant's solicitor, I'm going to ask you to deal with this, David. If the claimant's solicitor has taken the photos and measurements rather than the client, should he or she always prepare a witness statement exhibiting the photos to that statement? And if with the client when they were taken, which by the way, absolutely they ought to be, refer to the fact that the client was with them when the photos were taken?
Yeah, absolutely.
I agree.
You just want to make it as absolutely clear as you possibly can as a claimant. You don't want to give the defendant any way in to try and sort of say, oh, there's a bit of uncertainty here, or they've got a bit of a problem here. Just, yeah, photographs with a statement, if it's you that's taken to them. You can even include a photograph of, your standard claimant, pointing at the defect. To make sure. But yes, little statement saying the time that's elapsed since the accident, any kind of, sometimes you see the spray paint has been put on the pavement nearby, or something has been indicated for repair, or sometimes something nearby has been repaired. Take note of all that, but as well, the important thing, try and get the client there with you.
Great, thank you very much. Thank you so much for your questions. Thank you so much for attending and participating today and taking part in the polls. Please, can I just remind you again to fill in the survey that will appear at the end. I'd like to say thank you very much to John Lindfield, and thanks very much to David Forster, and also to Emily Dalton and Hannah Eames for setting all of this up for us. Thank you very much, and have a great remainder of your afternoon. Thanks. Bye-bye.
Of course, thank you very much to our wonderful judge as well, Rachel Segal.
Yes, here.
Thank you.
Good afternoon all.
Thank you.
Thank you very much.
Bye-bye.